Do you know that it is very possible for you to be married and your marriage is invalid under the law? Okay. Now, when can your marriage be said to be void, therefore invalid under the law? The provision of the Matrimonial Causes Act, which governs matrimonial proceedings, actually outlines the following circumstances where a marriage can be said to be void and therefore invalid. For proper perspective, a void marriage is a marriage that is unlawful under the law. It is invalid from onset, dead on arrival, and there's no need to even approach the court seeking any order of nullity, of such marriage. Now that we have an understanding of what a void marriage is, the following are instances where a marriage can be said to be void under the law. So the number one circumstance, a marriage will be void if either of the party is at the time of the marriage is lawfully married to some other person. So at the point of your marriage, or at the time you are getting married to your spouse, you discover that your spouse is lawfully married to another person. So at that particular point in time, your marriage is void and invalid. Then the number two circumstance, if both parties, that is the husband and wife, are of the same bloodline from the same ancestor, this is known as consanguinity. Or if both husband and wife are having an existing relationship by marriage, for example, you as a man cannot initiate a marriage with your son's wife or your father's wife. And also it is against the law for a woman to initiate a marriage with her husband's son or mother's husband, and so on. This is referred to as affinity, and it is not acceptable under the law. We make reference to section 4 of the Matrimonial Causes Act. So also a marriage will not be valid under the law if it fails to comply with the requirements of the law in respect to the form of solemnization of marriage. For example, if it is not celebrated at a licensed place of worship or at the marriage registry, it is void and invalid under the law. Then the next circumstance, a marriage is not valid if both the man and the woman did not consent to the marriage, or if they consented under duress, that is, by force or by fraud. So a marriage in this circumstance is not, valid. So both the husband and the wife, or the man and the woman, must consent before coming together to make it valid. So the final circumstance when a marriage can be said to be invalid is when either of the party to the marriage is not of a marriageable age. The Child Rights Act states that a child can be recognized as an adult at 18 years and therefore can be said to be of a marriageable age at 18 and nothing less. So these are circumstances where a marriage can be said to be void and consequently invalid under the law. If you have any question in respect to this topic, forward a WhatsApp message to the number on your screen and your questions will be rightly attended to. In our next content, we are going to be examining instances where a marriage can be said to be voidable, meaning that the marriage is valid but can be annulled, which means cancelled, when one of the parties makes an application to the court for it to be dissolved. Information is all you need, and we are here for you.